Good afternoon, everyone. My name is Joanne Ong, and today I will be presenting on the topic the contemporary relevance of the maxim cuius est solum eius est usque and culum erat in feros. This maxim has long been a fundamental principle in English land law, and my focus will be on its continued relevance in the context of modern legal challenges, particularly with regard to airspace and subterranean rights. I'll also be discussing the impact of the case Bocado SA v Star Energy and other important legislative frameworks. To begin, let's first examine the maxim itself, ad caelum. This is a Latin phrase meaning he who owns land owns everything that reaches up to the heaven and down to the depths of the earth. Historically, this principle has shaped our understanding of land ownership, making it clear that property owners have dominion not just over the land surface, but also the airspace above and the subterranean space below. This maxim has served as a key concept in land law, reinforcing the idea of comprehensive land ownership. However, the application of this maxim has come under scrutiny in recent times due to technological advances, urban development, and environmental concerns, which has led to challenges regarding its relevance in modern legal contexts. In today's world, the traditional understanding of land ownership has been challenged by new technologies and infrastructure needs. For example, advancements in drone technology, air travel, and even satellite systems raise questions about the ownership of airspace. Similarly, the growing issues of subterranean space for mining, drilling, and carbon capture presents new issues around who truly owns the land beneath their feet. These modern challenges highlight the need for an updated interpretation of the maxim. While a landowner may traditionally have had control over the air and the underground, modern legal frameworks must now balance private ownership and public interests, such as infrastructure, environmental protection, and technological innovation. One of the most significant legal cases in recent years that address subterranean ownership is the case of Bocado SA v Star Energy Onshore Ltd in 2010. In this case, the Supreme Court ruled that on whether landowners have rights to the minerals beneath their land, particularly when they are accessed without consent. The court ruled that landowners do have rights to the resources below the surface, but also acknowledged that modern land use, such as energy extraction, could complicate the application of these rights. This case illustrated that landowners do have substantial control over subterranean resources, but also that such rights are subject to regulation and potential interference for the benefit of broader public needs. The ruling in Bocado essentially reaffirmed the traditional maxim regarding subterranean ownership, while recognizing that the practical realities of modern land use, especially for energy and infrastructure projects, require further legal consideration. Now, let's turn to the statutory framework and judicial precedents that influence land ownership today. In the UK, several pieces of legislation impact how the maxim is applied. The Land Registration Act 2002 and the Planning Act 2008 have helped redefine the scope of landowner rights. For instance, while the Land Registration Act recognizes the physical boundaries of land, it also allows for the right to be registered for airspace and subterranean rights, particularly in urban planning and infrastructure. Similarly, the Air Navigation Act 1983 has established that airspace, particularly for commercial and military use, is not under the sole control of landowners. These legal developments indicate that while the principle of cuius est solum is still relevant, it must now be balanced against public and commercial interests, such as environmental policies and urban infrastructure projects. So, Is the maxim still relevant today? The traditional idea of landowners having absolute control over the land above and below them is increasingly being questioned in light of modern needs. For example, the rise of drones has created debates about airspace ownership. Should landowners be able to control drones flying over the property? Or should this airspace be considered public? Similarly, underground rigs such as those involved in hydraulic fracturing or carbon capture challenge the idea that the landowner automatically controls the depths beneath the land. Furthermore, environmental and public interest laws, such as those related to the preservation of resources or the construction of tunnels and pipelines, often conflict with landowners' rights. These issues call into question whether the maxim in its traditional form is still fit for the purpose or whether the law must adapt to modern demands. In conclusion, while the maxim cuius est solum continues to provide a fundamental principle in property or land law, its application today is more complex. The Bocado case demonstrated that landowners still have significant rights to subterranean resources, but modern statutory frameworks and judicial precedents show that these rights must be weighed against public and technological interests. As land law continues to evolve in response to technological and environmental needs, it is clear that the maxim must be carefully reconsidered and adapted to modern realities. Now, thank you for your attention, and I will conclude with my references.